afternoon, good evening, wherever you are. I hope you can see my presentation now, and it is full slides. If not, please let me know. So you can see. Okay, perfect. Thank you. So the topic of my today's presentation, again, first of all, thank you to Professor Chang. Thank you for CUHK Law for this opportunity. It's a great opportunity for me to share some preliminary conclusions of my research I'm working right now. And the topic, I think, shall be interesting for a lot of people because it touches upon two major issues. One of them is public-private partnership as a legal concept, as an instrument, which now undergoes interesting developments in terms of effect the so-called sustainable development goals have on PPP as a legal concept. And second, it touches upon the topic of energy transition, in particular, just energy transition. And I will briefly elaborate on this concept as well, because again, public-private partnership as a legal instrument and just energy transition, they're very much connected, and they depend, success of both of them depend on each other a lot. So just to give you basic understanding of what my presentations will be about and what kind of arguments I will make at the result of this presentation, to basically to save time for those of you who will not be able to stay with us for the whole period of my talk. So the main arguments are on the slide. So I have three main arguments. The first argument is, it's strange enough, but despite that renewable energy projects are by default supposed to promote good, they're supposed to promote energy transition. Interestingly enough, some of these projects can promote so-called unjust energy transition. So basically, they promote not good for the people, for the planet, for the environment, but they make situation even worse. And this is one of the paradoxes which we can see based on the case studies I will give you in this presentation. Second argument I want to make, again, is that public-private partnership as a legal instrument seems to be the most appropriate legal instrument for promoting and for enabling the just energy transition. There are a number of legal instruments that can be used for enabling just energy transition, but it seems that PPP, public-private partnership, is the most appropriate one. And the final argument I want to make as a conclusion is that the success of just energy transition largely depends on the success of international unification or harmonization of laws on PPP. So again, if we want as a humanity to achieve the goals of just energy transition, my argument is that it's crucial that we shall enable proper legal framework for PPPs in all our countries. This is a slide which gives a little bit of information about what energy transition is, because I can appreciate that some of you may not be in the topic, may not be do not have clear understanding of what energy transition is. So again, energy transition, if to put it in simple words, is basically transition from one type of fuel that people used for heating, for lighting, which, as you can see on the slide, started from like burning the wood, burning some coal, etc., progressively to other types of fuel. So nowadays we have, if you look at the slide, we have a number of different alternatives: renewable energy, nuclear power, gas, oil, coal, etc. So some scholars say that some countries stuck at the second energy transition, some at the third energy transition. So basically, for example, if we speak about the region which I will use as a case study, Central Asia, I can roughly say it's stuck at the second energy transition because it's still some of the parts of the region still use not even coal, they still use wood and other garbage, whatever they can find for heating and for lighting of their homes. So it's not, we cannot even talk about artificial intelligence or about renewable energy if some people even cannot afford gas and coal to be used at their homes. So what is just energy transition? Slide before showed you that there is a process of energy transition. So basically, people all around the world, they change the fuels they use for lighting, for heating. But the process of energy transition is not will not make what it's supposed to do if it is not just. So again, I will try to say in simple words to make clear my ideas. Briefly, there is no universally accepted legal definition of what is just energy transition. So different legal scholars, not only legal, but economics and other scholars have different opinions of what just energy transition is. So there is no universally accepted definition, neither legal nor economic. It is generally understood that just energy transition shall be considered just if only it provides basically a fair distribution of burdens and benefits. As an example, there is a concept of climate colonialism in the scholarship. Basically, the fact is that average person from a global south, as you can see on the slide, for example, a person from Africa consumes just a portion, like 1/10, 1/5 of the energy, which is normally consumed by average European or person in global north. So once humanity, the people all over the world decided that we have to do something about the climate change, we have to do something about energy transition, we have to take into account this fact, because if we will make all countries, all people all around the world to switch at the same time, in the same manner, for example, from coal or from gas to renewable energy, it will not be fair, it will not be just, because it will be unjust energy transition. Because again, global north, some people say, actually exploited resources of the people of global south for a long time to be able to prosper. And now, once, for example, China tries to catch up with the countries of the West, it definitely has some valid points saying, come on, guys, I know you're already kind of rich enough to be able to change the source of energy, but I cannot afford at the same pace to change mine energy source of energy. So this is basically, in simple words, the arguments about just energy transition and about climate colonialism. So the energy transition shall be just, and it shall not leave anyone behind. Like, and just energy transition is not about, again, don't take it wrong. It's not about only global south or global north. Even within any particular country, for example, UK or United States, also just energy transition suggests that all levels of society shall not be left behind. For example, the workers on the coal mine, they will lose their jobs if the coal mine will be closed by decision of the government. So just energy transition shall make sure that the energy transition happens but in a just way. And as you can appreciate, we as lawyers, and the law itself is all about equity and justice. So that's why this topic is very relevant. That's why it's very interesting for me as a lawyer. Why international harmonization, or another term we can use, unification of laws on PPP, also important? Let me again give you a little bit of background, because I want everybody to be on the same page as I, in terms of understanding of case studies. I will elaborate further. So what is PPP and what is international harmonization? So as I mentioned before, PPP basically is a legal instrument. And in simple words, very basic, for me to be able to explain what is it. Basically, PPP is a special category of commercial contracts whereby one of the counterparties of this commercial contracts is a state or entity of the state. So basically, it's a kind of a subtype of governmental contracts or so-called investor state contracts. It has its own unique features, PPP as a special category of contracts, and it is subject to special rules and special legal principles. And I have to note that PPP as a legal concept undergoes right now a process of convergence. So till recently, there was no universally accepted legal definition, and there is a wide range of different legal scholars arguing in different countries what PPP is. There is still actually no consensus of what PPP is. For example, if you ask a lawyer in UK what PPP is, he will say one thing. If you ask a lawyer in France, it will have completely different opinion, because even legal nature of PPP contracts are different in different countries. But I will save you time, because again, the main issue is you have to remember PPP is basically a special category of contracts, so-called investor state contracts. Still recently, there was no universally accepted legal definition, but something had changed recently. The first thing, the most important one, their organization, so-called UNCITRAL, adopted model legislative provisions quite recently in 2020, which provide a legal definition, first time in history of our world. It provides now a legal definition of PPP. One can argue, and actually that's my argument I make, that the legal definition provided by UNCITRAL shall be considered finally at last as a universally accepted legal definition, because UNCITRAL is a specialized international organization responsible for international unification of private and commercial laws. So basically, again, if to say it simply, model law, because model legislative provisions, so-called model legislative provisions, de facto, it's a model law. It's one of the so-called soft law instruments. Basically, this soft law instrument enables scholars like me and you to say that there is now universally accepted legal definition of PPP. So we can now, lawyers all around the world can now have kind of international standard, which enables us to compare against our domestic laws and domestic legal doctrine and say, okay, now we have something in common. Now we understand what shall be considered PPP as PPP from international commercial law perspective. And by international, also called transnational commercial law, I argue we shall consider so-called common theory of private law. Because I, as a legal scholar, truly believe in universalism of private law. So basically what I say, what I believe in is that private law all around the world eventually will be unified, will be harmonized. And I mean, if needed, we can, you can refer to a recent article I published on this topic. So the main argument I want to say, PPP is no longer merely a generic umbrella term. It is now a sui generis legal concept of international commercial law. And that means that we have a common standard, common understanding of what PPP as a legal concept is for legal scholars, again, in any country. So UNCITRAL now provides a legal definition of PPP. On top of that, important for our today's topic is that UNCITRAL model legislative provisions, they provide so-called legal principles. And you have to remember, please take a look on this slide, because that's very important for our further discussion. So to be able to qualify from legal perspective as true PPP, a project, a contract shall meet these requirements, shall meet these principles of PPP: transparency, fairness, stability, proper management, integrity, competition, economy, and most importantly, long-term sustainability. These terms are self-explanatory, so I will not go into details to save time. But again, these are important to remember, because unfortunately, for example, the case study of my country, of Kazakhstan, shows that there is a problem of so-called fake PPPs. What do I mean by fake PPPs? It means that Kazakhstan adopted back in 2015 national domestic PPP law, which was drafted in a way that it allowed governments on the ground, local governments in different regions, to proceed with projects which on paper were PPPs, but de facto they were not PPPs. It was so obvious that even the president of the country, Mr. Tokayev, in 2019, officially recognized that the concept of PPP was basically misused, and it was discredited by officials. So we have to do something with our legislation, and it's still a problem. I can say, based again on my practical experience, most of the projects, roughly, at least, I think, again, this is my subjective opinion, at least 80% of the projects, especially the projects which do not multilateral development banks like EBRD, Asian Development Bank, etc. So if these IFIs are not involved, if these projects have been structured on a local level, not a national level, 90%, 80%, they were fake PPPs. They are not true PPPs. They don't meet these legal principles, at least one of them. Even national level projects in Kazakhstan, and I can say most probably in other Central Asia, where are not and were not true PPPs, are fake PPPs. So again, that's just explains why I want to stress the importance of the legal principles of PPP and why we have to spend time on this. Now we go to another important issue, so-called sustainable development goals. Again, I will assume that some of you never heard about this term, so I will again try to make sure that everybody is on the same page. So sustainable development goals basically are the global goals which have been identified and promulgated by the United Nations back in 2015 at the United Nations Summit. There are in total 17 goals, which humanity, again, all people all around the world decided shall be pursued. Basically, to combat poverty, to promote, ensure, for example, for us, it's the most important is sustainable development. Number 7, ensure access to affordable, reliable, sustainable, and modern energy for all. So basically, humanity identified the common problems, and it set itself a goal by 2030, it shall achieve these goals, so-called sustainable development goals. And the most important word in this term is sustainable. So basically, these goals shall be achieved in a sustainable way. It's not they shall be achieved at all cost, but the final result shall be sustainable. That's why it's also important that sustainable development goal number 7 talks about affordable, reliable, sustainable, and modern energy. So it's not only clean energy, it shall be at the same time affordable, it shall be reliable. Again, this is important for my for arguments I make. And it was clear from these sustainable development goals that PPP, again, as a legal instrument, plays a crucial role in enabling many of the sustainable development goals, not only one, the one I mentioned, the Sustainable Development Goal number 7, ensure access, but most of them. So again, PPP is crucial for achievement of Sustainable Development Goals. What is PPP for SDG? So PPP for Sustainable Development Goals is a new legal concept which was proposed by another international organization, part of United Nations, basically United Nations Economic Commission for Europe. So United Nations, as you know, has a little bit bureaucratic structure. So one of the parts, basically, of the United Nations, which is responsible for one particular region, which is Europe and Central Asia. Interestingly enough, why Central Asia is together with Europe, but they have it this way. So this particular division of the United Nations initiated a new development by proposing a new model law. Again, this is interesting development because within United Nations, we have two different parts. One is UNCITRAL. Again, UNCITRAL is also part of United Nations. It's a specialized division of United Nations responsible for unification of commercial law. And we have UNICE. And both of them proposed almost at the same time competing model laws on the same topic, on PPPs. UNCITRAL says, it called it model legislative provisions, but again, de facto it's a model law. And UNICE proposed another model law, but it says, again, I will make it simply. Basically, UNICE said, yeah, we know about UNCITRAL, but it's not redundancy, because what we propose is it's very different, because we actually promote a different concept, which we call PPP for SDG. Because we say, I mean, I talk on behalf of UNICE, I mean, I kind of improvise. We say, UNICE says that UNCITRAL promotes the concept which is a little bit out of date, because it promotes only the so-called value for money. Basically takes into account only economic efficiency of projects. Whereas UNICE says the legal concept of PPP for SDGs enables basically to catch all other values, basically the value for people, value for the planet. So the argument UNICE has is it's important that we promote this a new universal. Universal means it can be applied all around the world. It's not only tailored for Europe and Central Asia. It can be actually took as an international standard by countries all around the world, because it was drafted by lawyers and scholars which represent different legal systems, common law jurisdictions, civil law jurisdictions, and it was, again, from the outset to be used, planned to be used as a universal model law. So again, now we have two legal concepts. One legal concept is PPP, proposed as a universal legal concept by UNCITRAL, and second legal concept, PPP for SDGs, which basically a legal concept which provides a new model of PPPs, which shall take into account so-called 10 UNICE guiding principles on PPPs. And again, it's important because UNICE model law says that it's that PPPs for SDGs, through PPP for SDGs, shall meet not only UNCITRAL legal principles I mentioned before, 8 principles, but also on top of that, it shall such kind of projects shall meet 10 specific guiding principles on PPPs in support of the Sustainable Development Goals. So in total, such kind of projects which can be qualified as PPPs for Sustainable Development Goals, for SDGs, in total shall meet 18 legal principles. So it's a big difference, at least on paper. I will give you just two examples of what kind of principles we're talking about. UNICEF legal principles on PPPs for SDGs. Again, you can read yourself on the screen. Principle number 5, disclose more information about project to society, especially on the commitments made to various partners in the project. Makes sense. Principle number 7, set out clearly the project selection criteria to promote value for people so that the best project aligned with the SDGs can be selected. Again, to me, sounds reasonable. UNICEF hasn't stopped on this. Actually, UNICEF and the team within UNICEF actually provided additional tools and standards which can be used by governments, by lawmakers in different countries for promotion and for implementation of the concept of PPP for SDGs. One of them is a online platform. So basically, what it is, you can go to the site of UNICEF. You can type in certain information about the project which you are working on or which is supposed to be implemented, and you can, based on the input you will give into the system online platform, you will see the result, whether the proposed project actually meets or doesn't meet the criteria to be qualified as true PPP for SDG. So if this system, if this PIERS as abbreviation, People First Infrastructure Evaluation and Rating System, will work as it is suggested, it will be a very useful tool because it will again help the countries, the governments, to address the problem of fake PPPs I mentioned before, which is a big problem, for example, in Kazakhstan right now. On top of that, UNICEF proposed another tool, useful tool. It's so-called standard on PPPs in renewable energy. Actually, it has a number of such kind of standards in different sectors of economy. But for our today's presentation, the most important one is definitely the one related to renewable energy. It provides certain guidance and tools for implementation of PPPs as so-called PPPs for the SDGs in the renewable energy sector. So let's summarize together. The information I just gave you. So one may argue there is already universal legal definition of PPP proposed by UNCITRAL because again, UNICEF is not a specialized unification agency. It's not a special. It's not, to be honest. It doesn't have a reputation. It doesn't have a mandate to propose universal model laws. So UNCITRAL, strictly speaking, is the only organization which has a reputation and mandate authority to propose universal model laws. So strictly speaking, there is now a universal legal definition, but it is the one provided by UNCITRAL, not UNICEF. Second, there are strong doubts. I mean, I have, to be honest, strong doubts about whether there is indeed a real difference between PPP and PPP for SDGs as legal concepts. I'm still working at it. My research is still in the process, but my preliminary conclusion is that it seems that, to be honest, PPP for SDGs as a legal concept doesn't add much value. So if any project already complies with the legal principles provided by UNCITRAL, the 8 principles I mentioned before, automatically, by default, it will meet the legal principles for SDGs. So basically, the legal principles, the criteria which provided by UNICEF PPP for SDGs, they are just more detailed. They are very helpful actually because they go into more details, but on high level, on principle level, UNCITRAL provided sufficient amount of guidance and regulation and principles which shall be sufficient for countries to implement proper PPPs, which will enable SDGs, even if they are not called PPPs for SDGs. So again, This is my preliminary conclusion, and I will come up with more arguments in support of my preliminary conclusion in my further research. But this is my conclusion at this stage. And the final point I want to make about in relation to the question I have, what is PPP as a legal concept? Actually, PPP as a legal concept has its roots in so-called IPP projects. So basically, some legal scholars argue that the PPP contract and the PPP as a legal contract was actually has its origin in so-called independent power producers projects. So in energy sector, any energy lawyer who works on IPP projects, in effect, he works on PPP projects. So the structure, the idea of PPP has its roots, some connection with energy law, actually. So next slide. So what is the role of law? Now I gave you a little bit background to information I have. Now, what is the role of law, and what is the role of us as legal scholars and legal practitioners in enabling a just energy transition? Many legal scholars argue, in particular, one I can mention is Professor Anatol But. In his works, he argues that adequate investments in renewable energy is a central part of just energy transition. So again, in simple words, we can say that, I mean, it makes sense. If you don't have enough money, if you don't devote enough resources for construction of renewable energy plants, you shall not expect not only just, but any energy transition. But paradoxically enough, even if government policy, if government is very keen to proceed with energy transition and manage to attract sufficient amount of money, it doesn't necessarily results in just energy transition. And let's now go to the main slides of my presentation, because again, all what I just discussed so far was just a background to make sure that all participants are on the same page. So the main argument is the selection of right legal instrument is crucial. So the law is very important for enabling just energy transition. And I argue that PPP is, if properly structured, is the ideal legal instrument, the ideal policy to be used for implementation of renewable energy projects, because it helps the country, the community, the people to achieve the so-called energy trilemma. Again, this is the concept which is often used in scholarship. Energy trilemma is basically any project shall meet at the same time three goals: equity, security, and sustainability. If one of them is not met, it can be a problem. So PPP, if properly structured, enables to achieve the energy trilemma. That's why I argue that PPP shall be used as ideal legal instrument. This is a map of the region which I chose as a case study for my topic. And again, just to give you a little bit kind of visual understanding of which part of the world we are talking about, we will talk about. This is a map. So basically, this is for China, for Chinese, it will be western part. For Europeans, Europeans will call it from the times of Alexander the Great, if I remember correctly, it was called Turan, Turkestan. I think ancient Greeks called it Tranks. I forgot, to be honest, the name. So again, this is the part of the world which basically connects Europe and Asia. It's just the middle of Eurasian region. And I will talk specifically about only 5 countries, post-Soviet Central Asian countries: Kazakhstan, Uzbekistan, Turkmenistan, Kyrgyzstan, and Tajikistan. Why I think this region is especially relevant as a case study? Because this region undergoes significant changes in terms of energy transition, and its problems this region faces and experience can be very useful for elaboration and kind of understanding of what kind of problems can be faced and will be faced by many other countries in other parts of the world. Let me explain you why. So what are the common problems in Central Asia? To give you a little bit of context. The Central Asian region, all 5 countries face the same climate change challenges: the scarcity of water. Basically, just recently, for example, Kyrgyzstan and Tajikistan, they had to declare energy emergency on a national level. So they officially declared energy emergency. What it means both of these countries, they depend a lot on water for producing electricity, because much of the energy production is based on hydropower. And as you probably know, because of the climate change, a lot of glaciers, a lot of snow melting right now, and there are not much glaciers left in the mountains of Kyrgyzstan and Tajikistan. And last 2-3 years, they faced a real challenge in terms of not only to produce energy using this water, but even to feed the cattle and even for agriculture purposes. So climate change, it's a big issue for all countries of Central Asia. It's problems with deserts, with lack of water, and with other climate issues. Energy deficit, another common problem. Last 2-3 years, all countries, not only Kyrgyzstan, but also Kazakhstan, Uzbekistan, and the rest, they face a big problem of energy deficit. So basically, if you will go to these countries, you can end up sitting in the room without light, which is not, again, very appealing prospect, especially taking into account that all these countries are very rich in terms of resources. They have a lot of oil, gas, etc., but for some reason they cannot even provide themselves with electricity. Third problem: cross-subsidization of electricity tariffs. This is another interesting and big problem for all these 5 countries. But basically, this is a legacy of Soviet Union. So in Soviet Union times, water, electricity was basically free good. So there was some kind of a social contract between the state and the people, which said, you don't riot, please don't riot, you don't make any noise, state says, and I will give you very cheap or free of charge utilities, light, etc., etc. So people got used to free or very cheap utilities, including electricity and water and gas, etc. So there is still bad practice of cross-subsidization. So basically, for example, if we speak about electricity, government has used crumbling energy infrastructure, which still was constructed back again like 50 years ago, without investing any money in building new electric grids and new power plants. For example, in Kazakhstan, no single power plant was built within last 30 years. And Kazakhstan now faces a huge problem with energy deficit. We have to import a lot of electricity from Russia. We have to ask for government of Tajikistan to give us some electricity. So there are a lot of problems because of, again, practice of cross subsidization, because no investor will come and invest and build any power plant if it knows that the legal framework which is currently exists doesn't enable it, such projects, to be bankable, to be investment attractive. Because again, if low tariffs provided by the law, it means I will not be able to give to have enough sufficient return from electricity tariffs. And if I don't have enough sufficient return as an investor, I will never invest in any energy infrastructure. And one of the biggest problems for renewable energy in particular is that, for example, again, it's basically about all countries, but I will more specific about Kazakhstan. For example, in Kazakhstan, there is now a big problem with the national grids, the electricity transmission lines, because even existing minimum of renewable energy power plants already constructed, and our national grid cannot cope, cannot digest this energy produced by renewable energy plants, because it's crumbling, it's deteriorating, and our national grid operator, CUHK, actually is very hesitant to proceed with renewable energy projects until it will be able to reconstruct, to do something with its grid lines. Similar problem with lack of flexible capacity, so-called maneuverable capacity. Again, I will explain in simple words, if because again, this is a little bit specific topic. So basically, as you can appreciate, yeah, renewable energy sounds like a great idea. You have a sun, it's for free, and electricity basically for free. You don't have to do anything. You put the sun battery, and here you are. You have a lot of free and cheap and clean energy. It doesn't work that way. For example, if you have a solar power plant, sometimes it's getting dark. Every day, actually, it's getting dark. So whenever it's getting dark, you don't have electricity coming from your solar power plant. And during this time, actually, there is a peak of usage of electricity, because when it's getting dark, you want to see, you want to read, you want to have a light. So that's when you need so-called maneuverable capacity. Usually it's represented by gas power plants or nuclear power plants, or anything which can provide not intermittent but constant electricity capacity. So basically, whenever renewable energy cannot provide sufficient amount of electricity, the backup shall be some kind of fossil fuel power plant, like, for example, a gas power plant. And in Kazakhstan, it's a big problem, for example, because we have ambitious plan to build a new renewable power plants, but we don't have enough maneuverable capacity. We don't have enough gas power plants. We don't have enough even coal power plants. So there can be a situation when we have lots of renewable energy power plants, but at night or when there is no wind, we will not have electricity, which again would be disaster. And final point I want to make is a water energy nexus. So the region is very specific and very interesting because there is a strong water energy nexus. I mentioned already before that this region is subject to big problems because of the climate change. This picture shows the result of the so-called Aral Sea. There was a fourth largest lake in the world called Aral. It's called sea, but it's basically it was lake, and now there is no lake. So you see ships on the bottom of this one time existed lake, and it's not anymore. It's now became a desert. And the point I want to make is, if we talk about energy, if we're talking about doing something with energy transition and just energy transition, we always have to have in mind water aspect, because again, Central Asia is a good example that if you want to do something with energy, think about water as well. Now, another important information which I briefly mentioned. If we talk about energy mix, the countries of Central Asia, they have different energy mixes. So some of them rely on gas, some of them rely on hydropower, like Tajikistan and Kyrgyzstan, because they both small countries in the mountains, and some of them, like Kazakhstan, heavily rely on coal. For example, in Kazakhstan, more than 80% of electricity is produced on coal power plants. So as you can appreciate, it's not a very green source of energy. Another important fact to know about just energy transition context related to Central Asia is that all 5 countries ratified the Paris Agreement. Again, for those who don't know or never heard about Paris Agreement, so basically it's kind of international undertaking, which was ratified in 2015. Again, actually 2015 was quite productive in terms of humanity to do something about energy transition and climate change. So we already discussed about 2015 that Sustainable Development Goals and agenda was ratified. Later, same year, the Paris Agreement was promulgated, and this Paris Agreement, in simple words, it's an undertaking by all countries all around the world to decrease the amount of carbon emission. So all five countries of Central Asia, they undertook officially, legally binding obligation to decrease the carbon dioxide emissions. 2 of them even set officially national net economic targets. So basically, Kazakhstan by 2060 and Kyrgyzstan by 2050 officially declared that by that years they will have 0 emissions. Tajikistan, Turkmenistan, and Uzbekistan, as far as I'm aware, I mean, I tried to find publicly available information, haven't set such kind of official targets for net zero, but they have some similar targets anyway. So this slide again give a little bit of more graphic information. Again, all data, all facts I provide are from public informations from different websites of international organizations like UNICEF, World Bank, etc. I don't cite them all here because this is presentation. This is not an article, so I cannot cite them properly. But as you can appreciate, this is PowerPoint. This is not an article. This is energy mix, and this is picture provides graphic again information about who is which sector of economy is the biggest polluter in the region. In all 5 countries, it's energy sector. So interestingly enough, even in Kyrgyzstan and Tajikistan, which mainly rely on hydropower, still energy sector is the biggest polluter and emitter of gas dioxide. Now we come to the renewable energy investments in Central Asia. What you have to be aware of. Till recently, Central Asian countries were quite hesitant in terms of investments in renewable energy, but things have changed in about 2018. From about 2018, it was like a bonanza of all countries rushing to try to attract foreign investors, especially Kazakhstan and Uzbekistan were very successful in terms of trying to lure foreign investments from Middle East, from China, from Europe. And nowadays, 6% of capacity in the region already represented by wind and solar, but it's still not much. and a lot of investments, a lot of foreign, especially investments and technology are needed, as you can see on the slide. Official statistics shows that trillions of dollars are required to enable the region to proceed with renewable energy investments in the way which will enable just energy transition. Now we come to the question of, okay, we have to proceed with energy transition. How we can do it? Interestingly enough, all 5 countries of Central Asia have different ideas how to proceed with energy transition, and they propose different strategies and even use different legal instruments for implementation of renewable energy projects. I will mainly concentrate for the purposes of my presentation on Kazakhstan as the most interesting example. And I don't want you to spend much of time on other countries, but I will give you very high level understanding of what's going on in other countries as well. So Uzbekistan and Kyrgyzstan rely on PPP. So they are good examples of how to do things right. So from the outset, Uzbekistan proceeded with the help of international financial institutions like IFC, EBRD, Asian Development Bank, with implementation of renewable energy projects under the framework of public-private partnership law. Kyrgyzstan also just now started, but it's already started using it PPP as a legal instrument. Now let's go to our main actor or object of the research of today's presentation, which is Kazakhstan. So what Kazakhstan is doing in terms of renewable energy, energy transition, and PPPs. So Kazakhstan was among the top 5 countries, developing countries in the world in terms of attracting international investment in the 5 years from 2015 and 2022. And I can say that from my perspective as a lawyer, I can say indeed this is explainable achievement, because Kazakhstan actually managed to during this last 10 years to create quite good legal framework for renewable energy projects. It started first with so-called feed-in tariffs, then it changed to the auction system. Again, I will not go into details what means feed-in tariffs and what it means auction. For those of you who know this, you know that the system of auctions proved to be more successful in terms of securing the best deal for host government. So as of today, there are 164 renewable energy power plants, which represents roughly 5% of energy mix. And the official target is 15% by 2030. Just last month, there was adopted an action plan by 2035, which provides information you can see on the slide, which basically says that renewable energy shall reach roughly 5% by 2035. Interestingly, nuclear power will have its own stake as well. There are now heated discussions in Kazakhstan whether we shall proceed with nuclear power plant or not. Nuclear power, strictly speaking, internationally is considered now as one of the types of renewable energy, which is, again, doubtful, but this is not the topic of our discussion for now. This is the most important slide of the whole presentation. So what kind of legal instruments in Kazakhstan are used and why this is a problem? Roughly, we can say there are 4 main legal instruments which can be used for implementation of renewable energy project in Kazakhstan. By default, it shall be the general framework provided by so-called renewable energy law, which provides for IPP model, independent power producer model, which is based on power purchase agreement, PPA, as a result of the auction. So this option number 1, which is used by default for all renewable energy projects implemented so far in Kazakhstan, so far, with a capacity less than 1 gigawatt. Since recently, the second option arose. It's the option which on the slide called Agreement on Investments plus IGA. IGA, I mean Intergovernmental Agreement. And as I understand, the state policy is to use this option for large-scale projects, for renewable energy power plants with the capacity of more than 1 gigawatt. And this would be the most interesting for our research option, because that's the option which I argue doesn't enable just energy transition. It enables energy transition, but unjust energy transition. And the third and the fourth options, they are basically subtypes of the same PPP. So basically, CUHK law has separate different concepts: PPP agreement, PPP concept, and concession agreement. So strictly speaking, if you want to do a renewable project in Kazakhstan, you can also implement it under the framework of either PPP law or concession law. CUHK law on paper allows it, but in practice, it has not. Both of these laws have never been used for renewable energy projects. For some reason, Kazakhstan decided that PPP specific legislation shall not be used for renewable energy projects. Instead of that, Kazakhstan decided to proceed with sector-specific legislation, the one I mentioned before, renewable energy law, which de facto is also PPP, because as I mentioned before, IPP is actually the subtype, is just a specific type of PPP contracts based on international legal scholarship. But in Kazakhstan, the jure IPP is not a PPP. So these are the 5 projects which Kazakhstan declared recently, again, just 1 or 2 months ago, in its action plan until 2035. It will implement with the assistance of foreign investors. As you can see on the slide, 2 of them from the Middle East, 1 from Russia, 1 from Europe, and 1 from China. So it's interesting mix of the major geopolitical players for Kazakhstan. And it's interesting from the perspective of why these countries, why these particular companies, why they have been chosen. And in this action plan actually provides some more information. It also provides expected projects for small scale renewable energy projects. But again, this slide is only dedicated only to large scale renewable energy projects that are more than 1 gigawatt. And this action plan interesting and important because it provides information about the method, about the legal instrument that shall be used for implementation of these projects. So all these 5 projects suggested to be implemented on the basis of so-called agreement on investments. The concept of agreement on investments, it's very interesting. This is the type of the contract which has recently been introduced in legislation of Kazakhstan. So from CUHK law perspective, it's a contract nominate. It's a definite contract. It's basically contract which specifically provided by CUHK law. It's not a mixed contract, as we call it. It's a definite, it's a nominate contractor. And it means that this type of contracts shall be used for implementation of large-scale renewable energy projects. On top of that, at least 3 of them, that's, again, I rely only on publicly available information. And the problem with these projects that you cannot find agreements signed, at least final versions of these agreements in public domain. So I just rely on my understanding of just on publicly available information, which can be misleading sometimes, but anyway, it gives me some information for thoughts and for conclusions. So 3 of them provides on top of agreement on investments IGAs, international treaties. So let's go and see how this project, the legal framework for this, at least 3 projects, but most likely all 5 will be implemented the same way. So Kazakhstan attracted these investors, and instead of suggesting them to proceed with general framework, it allowed them to have a specific legal framework, to have a carve-out from our general legislation. So instead of saying, please proceed with implementation of your projects on level field basis with competing with others, it allowed them to have certain benefits and exemptions from Kazakhstan laws and regulations. How it was achieved? By way of international treaty, by intergovernmental IGA, intergovernmental agreement. So basically, international treaty, for example, between Kazakhstan and France, Kazakhstan and Saudi Arabia, Kazakhstan and UAE, as international treaty, which will have a prevailing force. The provisions of international treaty prevail over local legislation of Kazakhstan, and whatever is provided in this international treaty will will prevail over conflicting provisions of Kazakhstan law. So international treaty IGA creates an umbrella, specific legal legislation. So these investors, they don't have to care about Kazakh law if they have international treaty, and if international treaty allows them to do something which is not allowed for the rest of investors. Under the international treaty, there is basically de facto a PPP contract, which for these purposes, they used, again, the one I mentioned, agreement on investments. So an agreement on investments, unlike international treaty, is a private contract. It's a commercial contract. It's a commercial contract between private investor and state body. So unlike international treaty, it's not above the law. It shall comply with Kazakh law as revised by IGA. And underneath, we have a power purchase agreement between a single off-taker, in our case, Financial Settlement Center, which is a state-owned, dedicated for this particular purposes company, and which is 100% owned by the Republic of Kazakhstan. So this is unique legal framework for large-scale renewable energy projects in Kazakhstan. It's very unique. I mean, in Kazakhstan, international treaties as a means of achieving, of creating a specific legal framework for infrastructure projects has been used in the past. I work, for example, on Balkhash power plant, which is also a big energy, was supposed to be a big energy project in Kazakhstan, and there was also an international treaty. But to be honest, I thought this, again, this is my subjective opinion, this bad practice of creating ad hoc legal frameworks by way of international treaty is in the past. That Kazakhstan, especially with the change of the leadership after the bloody January 2022, I thought that the policy of Kazakhstan is not to do anything similar, not to basically step on the same, how it's called, not to make same mistakes, and not to do preferential treatment for specific investors. Interestingly enough, it's not the case. So we have now 4 instruments. One of these instruments is this unique legal framework for large-scale renewable energy projects. Now let's think together. I mean, you have information on the table, so we can think together with you. You can discuss, and I would be more than happy to hear your opinions after I finish as well. So we have now one general legal framework for small renewable energy projects, for the projects which are less than 1 gigawatt. And we have interesting practice of creating specific legal frameworks by way of international treaties and so-called agreements on investments for certain investments, for certain investors and from certain countries. So fact number 1, ad hoc international treaties that provide significant preference and exemptions from Kazakh laws for certain projects. Fact number one. Fact number two, there were no open tenders. At least not I am aware of. I don't know how these investors were selected, by what criteria and on what basis. Fact number three, opacity in contract provisions. Basically, I have no idea what kind of contractual terms we have in these contracts signed, what kind of preferences have been given. I mean, I can maybe see some information in the news, very little information, which is they very rationally give. But this, as I understand, contracts, even international treaties, I'm not sure that the ones I found in the public domain, they are final versions. It seems that some, at least of IGAs published, they are just drafts. So the final versions may be completely different. So confidentiality of these contracts, which are very important for the country. There's a huge investments, billions of dollars. We don't know what are the terms of the contracts. This is fact number three. And fact number four, I mean, as a Kazakh lawyer, it seems to me strange why they used this specific legal instrument called agreement on investments. Again, as I mentioned before, agreement on investments is contract nominati. It's basically поименованный договор in Russian. It's basically the contract which has specific designation and specific usage. It cannot be used for any other purposes. It's not a PPP contract, basically. It's one of the subtypes of the so-called investment contracts, which can be used, strictly speaking, only to provide so-called investment preferences, that is, tax exemptions and some kind of customs exemptions. So basically, in simple words, agreement on investments is, strictly speaking, is not a contract. It's kind of a license. So there shall be, it shall not be used for the purposes it's used in this case. So agreement on investments, I argue, is not an appropriate legal instrument for the purposes it has been used in the case of large-scale renewable energy projects. Okay, now we know the facts. Now we can make certain conclusions together with you. I mean, I may be wrong, but it seems that the decision to choose to proceed with large-scale renewable energy projects on the basis of these ad hoc international treaties and strange selection of agreements on investments, there is a sense of neocolonialism. So basically, I argue that Kazakhstan, the government of Kazakhstan, if it will proceed this way, risks to put in jeopardy the sovereignty of Kazakhstan, risks to put in jeopardy energy security of Kazakhstan. Why is that? Because I don't have clear answer to the following questions. Why do certain investors from certain countries have got preferential treatment? For example, if I were an investor from, let's say, Argentina or, I don't know, Germany, I would ask why this particular company from Saudi Arabia got this project. Why I even didn't know about possibility for me to get this project. Why on these terms? I even don't know. Most likely investors, other investors also don't know what kind of benefits, what kind of exemptions from the laws have been granted to these particular companies from these particular countries. Second question I have, and I don't have clear answer, is who will benefit and who will lose from such type of projects, energy transition? So again, having in mind that the final goal of the Kazakh government shall be not just energy transition, but it shall be just energy transition. So basically, Kazakh government shall have in mind that it's not that renewable energy project shall be implemented at all costs, that we shall meet the goals which they set for themselves. It shall, the achievement, the weight to the energy transition shall be reasonable, and it shall take into account the rights and interests, at least, of local population. So I, as a citizen of Kazakhstan, have certain doubts about whether these projects are reasonable in terms of whether it's reasonable to provide such kind of exemptions without open tender, whether it's reasonable to provide such kind of tariffs without even knowing what kind of price is fair and justifiable. The third question I have, who and on what legal basis agreed on the terms, including tariffs, on behalf of Kazakhstan? So again, in absence of clear legal framework, which provides, for instance, for PPPs, the authority of government of officials of Kazakhstan, who is responsible for what, such kind of ad hoc legal frameworks are very non-transparent, provide very ambiguous legal framework, and to me, it's not very clear who, in the end of the day, was the decision maker, who was in charge of agreeing the terms, who, for example, decided what kind of terms will be provided to investors from Saudi Arabia, why, if they are different from terms provided to investors from France or from China or from Russia, and why, again, why these 5 countries? Why, for example, not to investor from, again, from Australia, or I don't know, from Korea, or from any other countries? So the final question I have doubts, which I hope are not true, that the motivations from Kazakh government side are not good motivations. They are rather political rather than based on real needs of country and of the people. I mean, I want to be wrong, but it seems at least it was the practice again in before, which my subjective opinion is, before, especially during the presidency of the first president of Kazakhstan, there was a not good practice of doing infrastructure projects as a kind of a gesture of goodwill and show that we have a good political connection. For example, president of Kazakhstan wants to have good political relationship with president, I don't know, China or France or any Russia, and as a gift, kind of a gift, he says, please do this project. I give you this project, implement it, and I give you very good terms. And if you don't want to compete with other investors, don't worry, we will find a way how you will get this project without much worry. So again, the final point I wanted to make is the motivations are strange and they are not clear. The legal framework which was used doesn't give answers to these questions. So rhetoric questions, the questions which seems to be self-explanatory. The question number 1, it seems that same projects which have been implemented, will be implemented under this strange ad hoc legal framework, could easily be implemented under general framework. I haven't got any answer in any policy documents or in the law or anywhere which will explain me why large-scale projects cannot be implemented under the general framework of the renewable energy law. Or if you don't want to use renewable energy law, fine, you can use PPP law, or you can use concession law. And it seems that if you will use general framework, you will achieve even better results because, again, as I mentioned before, Kazakhstan faces a lot of problems. For example, our national grid company, I don't think our national grid company is happy with proceeding with these projects because one huge renewable energy power plant will make a headache for the deteriorating national grid operator. And it seems that it will be more cost effective, more environmentally friendly, and more beneficial for local population to build several small projects in different parts of the country, so not to charge over do the system in one particular place. Second, I have the question: is it just energy transition not only about the source of energy? Because it seems that the decision to proceed with these projects on the basis of ad hoc legal framework is justified only because we will have, in the end of the day, clean energy. But again, just energy transition doesn't suggest that the only goal is clean energy. It's not only about clean energy, it's also about other sustainable development goals. As we remember, one of the sustainable development goals, number 7, says energy shall be not only clean, but it shall be affordable, it shall be sustainable. So I have a little bit of doubts about whether sustainable development goal number 7 will be achieved by means of such kind of legal instrument we used on ad hoc basis. It seems that this problem is not only about Kazakhstan. Again, the case study of Kazakhstan and Central Asia in general can be replicated in other parts of the world. It seems that, for example, the same problem with renewable energy projects exists in, for example, in Australia. As you can see on this picture, some politicians consider renewable energy projects as an end in itself, which is wrong, because renewable energy projects cannot be considered as an end in itself. Renewable energy is just one of the means to achieve the sustainable development goals we have, but it shall not be considered again as an end in itself. So, to come back to the other countries of the region, Uzbekistan have even more ambitious plans for renewable energy, 40% by 2030, compared with 15% in Kazakhstan. Uzbekistan, from the beginning, with the help of IFIs, as I mentioned before, chose PPP as a legal instrument, which is the right decision, and competitive bidding process, which is by default provided by PPP laws. So again, Uzbekistan, unlike Kazakhstan, decided to go in the right way. Kyrgyzstan, just this week, Kyrgyzstan announced an open tender for implementation of renewable energy project by way of PPP. So what we can see, despite the fact that Kyrgyzstan has abundance of hydropower and more than 90% of its electricity already produced from big hydropower plants, Kyrgyzstan wants to have at least 10% by 2040 to be produced by renewable energy sources like solar, wind, and small hydropowers. And Kyrgyzstan, again, with the help of IFIs like IFC, decided to go into the right direction. It decided to proceed with PPP as a legal instrument for implementation of renewable energy projects. So to finish my speech, my presentation, why I believe international harmonization of laws on PPP is important, and why research, which I'm doing right now, hopefully will be interesting and I hope will make a difference, because it can address certain problems. It can address the problem of fake PPPs I mentioned before. It can address the problem of so-called cross-border PPPs. For example, Kazakhstan and Kyrgyzstan last year declared about implementation of joint renewable energy projects. So it will be one of the first cross-border renewable energy projects in the region. So to be able to proceed with such kind of cross-border, not only renewable energy, but any infrastructure projects, you need to have enabling legislation, PPP legislation. So again, international harmonization is crucial for these purposes. The third thing, Kazakhstan international harmonization will help to revive China's Belt and Road initiatives, because again, this is my subjective opinion, but Belt and Road struggles so far mainly because PPP have not been used for implementation of Chinese Belt and Road projects. So once China will stick to PPP as its main legal instrument for implementation of PPPs, I think it will make a big difference. And finally, international harmonization shall enable just energy transition, which is the main topic of my presentation, and it will help achieve the Agenda 2030. That's all. Thank you very much.
Thank you, Shaimerden. That was an excellent and very informative presentation, and I know that the audience have been listening very attentively. I've got loads of questions here, but unfortunately we're not going to have enough time to address every single question. So let me just give you a few questions that which seem to be very specific and relevant to what you're talking about. So first of all, could you maybe elaborate on climate colonialism that you mentioned?
Yes, climate colonialism I mentioned. So basically, there is a discussion, there is a discourse in scholarship, including in legal scholarship, about the way that energy transition shall proceed. And one of the aspects that shall be taken into account that, I mean, I will explain you as I understand this. So basically, the countries, the developing countries, they shall not be put in the same position in terms of addressing the problem of climate change as developed countries. So there was misuse of resources of developed world, developing countries by richer countries. So, and even today, a lot of people in developing countries do not use and do not produce as much as pollution as countries in richer countries, so they not shall be have the same level of burden as other countries in terms of energy transition.
Okay, excellent. And then got quite a technical question here. Under which situations would you use the three tools: international treaty, PPA, and agreement on investment in Kazakhstan?
Sorry, what?
Under which situations would you use those different types of agreements?
Yes. Okay. That's a very important question. Yes. So on the slide, if it's still on the screen, so the general framework so far has been used only for small-scale projects that are projects less than 1 gigawatt. And for projects that are more than 1 gigawatt, Kazakhstan government decided to use this new ad hoc legal framework. Let's put it this way.
Okay, that's great. And what is the level of adoption of the of PPP contracts adopting UNCITRAL provisions versus the UNECE provisions? I mean, I know that given UNECE provisions have only come out in 2022, but have you seen any of these PPP contracts adopting the concept PPP for SDGs?
Yes, actually, Kazakhstan already tries to implement, for example, the concept of PPP for SDG in its PPP law. But the problem is, as I mentioned before, Kazakhstan government doesn't use PPP agreement for implementation of renewable energy projects. So, so on paper, as you can see, there are 4 instruments that can be used, but in practice, only 2 instruments are used. First one is sector-specific renewable energy law. Second one is this ad hoc international treaty.
I see.
So one of the arguments I say that Kazakh government shall harmonize even on national level our legislation and bring in line renewable energy law, to bring in line renewable energy law with our PPP law as a prevailing, as a main law. Because again, renewable energy IPP projects, renewable energy projects, this is just subtype of PPP projects. IPP is just a special, as a subtype of PPP contract. So PPP law shall be applicable to renewable projects as well.
Right. So, but do you see private investors, wanting or preferring to use the PPP contracts, based on the UNECE provisions, given that it already incorporates the SDGs, and private investors are maybe for their own sort of considerations of meeting ESG targets, and would there be more of a trend going forward in terms of adopting sort of the PPP contracts with UNECE provisions by private investors?
Yeah, I believe that investors shall be happy to proceed with PPP law because based on experience of Uzbekistan and Kyrgyzstan, especially Uzbekistan, which proved that PPP is ideal instrument for implementation of renewable energy, and because Uzbekistan PPP law is pretty much based on UNCITRAL and UNICE as a models, so it seems that yes, I think Kazakhstan shall basically take into account lessons learned and good example of Uzbekistan. So basically, Uzbekistan showed a right way to proceed with PPP for SDGs.
So I'm afraid that's all we have time for. That was an excellent presentation, and I've had so much interest in your presentation, and I've even had a request for your paper.